Good moed, good vach. How's everybody doing? Great to be with you on a Saturday night or early Sunday morning on the East Coast. I'm so impressed with y'all tuning in. Let's get started. Let's do some beautiful learning. Let's light up the darkness. Who's in the house? Joe in the Inland Empire. Bella in Florida. Melissa in Great Neck, New York. Karen in Northern California. Sharon in New Jersey. Ella's in the house. Welcome, everybody. Let's be efficient so you can get to bed. Our daf tonight is page Nun-Hey, page 55, here in Tractate Bava Metzia, the 22nd volume of the Talmud, continuing our discussion of Mishna number 4, here in chapter 4. We pick it up near the bottom of page 54b. Rabbi Yehoshua ben Levi says, for redemption of first consecration, one adds a fifth. So, if you consecrated property as a donation to the Holy Temple when it was standing in Jerusalem for the upkeep of the temple, and you weren't going to really give them your field or your house, so you would deconsecrate that property, in other words, transfer its sanctity onto money, and then you would give the money to the temple treasury. And when you do that, you add a fifth, which is actually a protection lest you come to use sanctified, consecrated property for yourself. That is his own transgression called meilah, misuse of consecrated property. So you add a fifth when you deconsecrate it to make sure that you've added enough. However, although one adds a fifth for the first consecration, for redemption of second consecration, one does not add 1/5. So second consecration in this context can mean that you set aside this cow. I'm going to donate that. I'm hereby setting aside that cow. It's hereby consecrated. It's going to be donated to the temple. Or I'm going to have to transfer its value onto money and then donate the money. So instead of deconsecrating that cow onto money, you exchange another cow for that. Okay, instead of donating this cow, I'm going to donate that cow. Right? So now the second cow is consecrated. The first cow is not. If you then transfer the sanctity of the second cow onto money, you don't add the fifth. Rava said, what is the reason for the opinion of Rabbi Yehoshua ben Levi? It is, as the verse states, and if he who consecrated it will redeem his house, then he shall add 1/5 of the money of your valuation onto it. Leviticus 27:15. And from this, it may be inferred that when he who consecrates the house redeems it, he adds 1/5. But this is not so with regard to one who associates an item with an existing sanctity, as in this case, where the sanctity of the fifth is derived from its association, it is not the case, as in this case, where the sanctity of the 1/5 is derived from its association with the sanctity of the house. In other words, the law doesn't apply to the second item in the chain. So, the Gemara relates that the Tana who recited Mishnayos and Baraisas in the study hall taught a baraisa before Rabbi Elazar. And it is written, quote, and if it is a non-kosher animal, then he shall redeem it according to your valuation. Leviticus 27:27. And this verse teaches that just as a non-kosher animal that was consecrated is unique in that it is an example of initial consecration and it is devoted entirely to heaven, as neither the owner nor anyone else may derive benefit from it after its consecration, because as opposed to, when you set aside an animal, for example, to be a peace offering. Now here, by the way, when we're talking about consecrating animals, we might be talking about consecrating that their value goes to the temple treasury, or that we're consecrating it to become an offering, for example, a peace offering. Now, a peace offering, unlike, for example, a burnt offering, and we have no more offerings, but when the temple was standing, we did. So burnt offering was consumed entirely on the altar. There was no human benefit from it after it had been consecrated. A peace offering, part of it went up on the altar, part of it was given to the Kohanim, the priests in the temple, and part of it was eaten by the owner of the offering. A non-kosher animal is not fit to be offered on the altar, is not fit to be eaten. So once it becomes consecrated, it can't be used in any way. There's nothing left sort of for the humans to use of it until it is deconsecrated. Then the animal becomes unconsecrated and it can be used, but its value gets donated to the Holy Temple. So this verse teaches that just as a non-kosher animal that was consecrated is unique in that it is an example of initial consecration and it is devoted entirely to heaven, as neither the owner nor anyone else can derive benefit from it after its consecration, and one violates the prohibition against misuse of consecrated property, meilah, by using it after it was consecrated. For example, if you used it to pull your wagon, so too with regard to any item that both undergoes initial consecration and is devoted entirely to heaven, one violates the prohibition against misuse of consecrated property by using it after it was consecrated. So if, for example, you set aside a kosher animal to be a burnt offering, and then you used it for any purpose whatsoever, that would be meilah. So Rabbi Elazar said to the Tana, granted, the statement it is devoted entirely to heaven serves to exclude offerings of lesser sanctity. For example, peace offerings, because a part of a peace offering, even after it's been consecrated, does accrue to the benefit of the owner, right? The part that he can eat. Since the owners have a share in them, as they may partake of those offerings, they are not subject to the prohibition against misuse of consecrated property. But what does the mention of initial consecration in the baraisa serve to exclude? Is it that initial consecration is subject to the prohibition against misuse of consecrated property, and ultimate consecration is not subject to the prohibition against misuse of consecrated property? Right? In other words, if we exchanged a consecrated animal for another consecrated animal, and here we're not talking about offerings, because when you set aside an animal to be an offering and then you substitute another animal, that has its own set of complications. So now we're just talking about consecrating an animal or other property to be a donation to the temple treasury for the upkeep of the temple, and then you exchange that animal for another animal, right? So now they're asking, so does meilah apply to the second animal? We already said that you don't add a fifth if you deconsecrate the second animal. Is it subject to the laws of meilah, misuse of consecrated property? So even the property consecrated last in a series of redemptions is still full-fledged consecrated property. So why would meilah not apply? So perhaps it is with regard to the matter of the payment of 1/5 that you are saying this, and it is in accordance with the statement of Rabbi Yehoshua ben Levi. And the Tana said to him, yes, that is what I am saying. The fifth does not apply to it. I'm not saying anything about meilah. So apropos that baraisa, Rav Ashi said to Ravina, is it so that a non-kosher animal is subject to initial consecration, but it is not subject to an intermediate stage of consecration resulting from redemption? And Ravina said to him, and we're on page 55a now, it is due to the fact that it is not subject to ultimate consecration. A non-kosher animal does not ultimately remain consecrated, as it is used neither as an offering nor in the upkeep of the temple. Instead, it is redeemed and its value is consecrated. Right? If you let's say that you initially consecrated, I don't know, it could be 10 bushels of wheat. And then you said, you know what, instead of, I actually need those 10 bushels of wheat now, so I'm going to transfer their sanctity onto this cow. Now, in terms of the difference in value between wheat and a cow, we're coming to that. But I transfer the sanctity to the cow. Okay, now if I then say, okay, treasury, temple treasurer, here's the cow. It's consecrated. I'm giving it to you. Now, the temple treasurer might well say, why don't you sell the cow? Or he'll say, I'll sell the cow and convert it to money. And then the cow goes to its new owner or back to its original owner, and the money goes into the temple treasury. Or the temple treasurer might say, you know what, this is a qualified bull for an offering. We need an offering today. That's a bull. We'll sacrifice it. That could happen. But a non-kosher animal, you don't have that option because non-kosher animals were not sacrificed on the altar in the temple. So you knew that it was not going to end up being used. It had to have its value transferred to money so that the money could go for the upkeep of the holy temple. So Rav Acha of Difti said to Ravina, it is subject at least to an intermediate stage of consecration, right? The non-kosher animal could be in the middle of this series of redemptions. I'm sorry, where am I? It is subject at least to an intermediate stage of consecration, and in that case, let one add a fifth as well. Maybe you do add a fifth for an intermediate stage, but you don't add a fifth to the ultimate stage. So Ravina said to him, its legal status is like that of ultimate consecration. Just as one does not add 1/5 with regard to a non-kosher animal when it's the last animal in line of these substitutions, as that category does not exist in a non-kosher animal, so too, one does not add 1/5 in a case of intermediate consecration. Rav Zutra, the son of Rav Mari, said to Ravina, what did you see that led you to liken the intermediate stage of consecration to the final stage of consecration? Let us liken it rather to the initial consecration. Ravina said to him, it stands to reason that he should liken it to the final consecration in a chain of substitutions, as he thereby derives the law of an item consecrated by association with the sanctity of an item consecrated by association. Right? Its sanctity came because the item before it in that chain of substitutions was sacred, not because it was initially consecrated by its owner. The Gemara asks, on the contrary, he should have likened it to initial consecration, as he thereby derives the law of an item after which there is another stage of sanctity, the intermediate stage of consecration, from an item after which there is another stage of sanctity, the initial stage of consecration. So the Gemara answers, it is, as Rava says, the burnt offering in Leviticus 6:2, employing the definite article the, as opposed to an, or a burnt offering. He says the burnt offering. This indicates that the reference is to the first burnt offering. And so too, when it is written the non-kosher animal, the reference is to the initial consecration of the non-kosher animal, not some intermediate stage in a chain of substitutions. And the Gemara comments, it is taught in a Baraisa in accordance with the opinion of Rabbi Yehoshua ben Levi, if one said that this cow is in place of that cow, which belongs to the temple treasury, or this garment is in place of that garment, which belongs to the temple treasury, his consecrated property is redeemed, and the treasurer of consecrated property is at an advantage. What do you mean advantage? And this is where I say I'm trading, this cow for that cow. Well, maybe the cows are not worth the same amount of money. Maybe one cow is a lean cow and one cow is a fat cow. Or one cow is a common cow and one cow is a more rare and desirable cow. Right? So there could obviously be differences in value in this chain of substitutions. And as you can imagine, the temple is always going to win as this property is assessed because you want the holy temple to win, in the sense that you never want to even unwittingly end up using something that was actually consecrated and belonged to the temple. So how does it work in this situation? If the replacement item is equal to or more valuable than the original item, so the treasurer takes the substitute item. But if it is less valuable, then the one who consecrated it must pay the difference between the earlier item in the chain of substitution, or let's say the initial consecration, and the substitute item, which is worth less. So the one who deconsecrated the initial item and transferred its sanctity to the next item in the chain he has to make up the difference in money and give it to the Holy Temple for its upkeep. So if he said, for example, this cow valued at 5 selah is in place of this cow, which already belongs to the temple treasury, or this garment valued at 5 selah is instead of this garment, which belongs to the temple, his consecrated property is redeemed. Even if the second consecrated item is more valuable, it is not considered a consecration done in error. He will have to pay the difference. He adds 1/5 when redeeming the item that was the initial consecration, but when redeeming the item for which the initial consecration was already redeemed, the second consecration, then he does not add a 1/5. And that concludes our discussion of Mishnah number 4. Here is Mishnah number 5 of chapter 4. The measure of exploitation, right? So meaning you cannot charge more than 1/6, as we've talked about several times, above the market price. And if you do, then the buyer has a claim of exploitation and he can get the difference refunded or just unwind the deal. But that's not what this Mishnah is about. That's just the first clause of it. The measure of exploitation is 4 silver ma from the 24 silver ma of a selah. And the smallest monetary claim in court for which a plaintiff can obligate a respondent to take an oath, right, where there's not evidence, but he can obligate someone to take an oath that he didn't pocket it, for example. The smallest amount that someone can be obligated to take an oath is 2 silver ma. And the smallest monetary admission for which that respondent takes the oath is an admission that one owes at least the value of 1 peruta. Right? If, for example, I come and say, you owe me 100 selah, and you say, listen, Sal, I did owe you 100 selah. I've already paid back 40 of it. 60 is what I owe you now, not 100. And I don't remember that you paid me back 40, and I bring a claim against you. So in this case, because you admitted, you made a partial admission that the debt did exist, but that you paid back part of it, you would take an oath about the part that you paid back, and then my claim could only be for what you have not paid back. But now we're learning that there's a minimum the minimum value where you could be made to swear an oath for partial admission is 1 peruta, right? So 1 peruta, that was the smallest value copper coin, so think penny. Now, on a related note, the Tana adds that there are 5 halachic situations involving perutot, right? Involving a penny. The admission to part of a claim must be that one owes at least the value of 1 peruta, as we just mentioned. And a woman can be betrothed. You have to give some item that has at least the value of 1 peruta to create betrothal. And one who derives benefit of the value of 1 peruta from consecrated property. You're not allowed to have any personal benefit from consecrated property. What's the minimum amount of personal benefit, the value of the personal benefit? 1 peruta, which would make you liable for misuse of consecrated property. And one who finds an item that has the value of 1 peruta is obligated to proclaim that he found it. In other words, to perform the mitzvah of returning a lost object. And this only counts if the item has a minimum value of 1 penny. I mean, it's a pretty low minimum. But there are some things that are not even worth a penny, so then you don't have to proclaim that you found it. It's virtuous to do so, but it's not obligated. And with regard to one who robs from another an item that has the value of 1 peruta, and then he took an oath to him that he did not rob, so when he repents and seeks to return the stolen item, he must take it and follow its owner even to Metzia. If you want to make an atonement for robbing somebody of something, then you have to return it to him, even if he has traveled far away. Now you have to complete your atonement. You have to go and travel and find that person to return the object you robbed. So in that case, he may not return the item by means of a messenger. He must give it directly to its owner, and the minimum value of that is a peruta. That's the Mishnah. Now the Gemara. The Gemara asks, we already learned this on another occasion in an earlier Mishnah on page 49b, that the measure of exploitation for which one can claim that he was exploited is 4 silver ma from 24 silver ma in the selah, i.e. 1/6. That's where we learn the law of 1/6 for exploitation. So the Gemara answers, it was necessary for the Tana to mention 2 laws. The smallest monetary claim in court for which a plaintiff can obligate a respondent to take an oath is 2 silver ma, and the smallest monetary admission for which that respondent takes the oath is an admission that one owes at least the value of 1 peruta. Therefore, the Tana cited the laws of exploitation appropriately in this context. So the Gemara asks, that too was already learned in a Mishna, in Tractate Shavuot 38b. So the oath for admission to part of a claim imposed by the judges is in a case where the claim is 2 silver ma, and the admission is the value of 1 peruta, right? So the claim has to be at least 2 silver ma, and when you say that I've already paid back part of it, that partial claim has to be at least worth a peruta for this to work. So the Gemara answers, it was necessary for the Tana to teach the latter clause of the Mishnah, as it teaches there are 5 halachic situations involving perutot, which is not taught elsewhere. That list of 5 was only taught here, and that's why it's mentioned here. Now, the Mishnah teaches there are 5 halachic situations involving perutot, right? Something based on a peruta. So the Gemara asks, and let the Tana also teach that the measure of exploitation is 1 peruta. That was not included in the 5. So Rav Kahana said, that is to say that there is no exploitation concerning perutot. Any disparity between value and price that is less than the value of the smallest silver coin and isar, which is worth 8 perutot, is not considered exploitation, right? So if the object is already worth so little that the 6th ends up being worth less than a penny, so then we don't get involved with exploitation. And Levi says, no, there is exploitation even for perutot. And likewise, Levi taught in his version of the Mishnah, which parallels the Mishnah redacted by Rebbe, that there are 5 halachic situations involving perutot, and his list was like this. The measure of exploitation is 1 peruta, the admission is the value of 1 peruta, partial admission of a debt, and the betrothal of a woman is 1 peruta, and the law of one who takes an oath denying a robbery applies in the case where he denies having robbed another of at least 1 peruta, and the convening of judges to adjudicate a case of monetary law is in a case where the claim is at least 1 peruta. Right? I mean, this goes to show you how important it is to follow Torah law, and where there's a mitzvah to perform it. They're saying they're going to call a beis din, right? They're going to assemble a rabbinic court and judges to hear a case where the claim that's being argued has a value of at least 1 penny. Yeah, most civil courts will not accept a claim where the item is valued at 1 penny. But if there is a claim under Torah law, it will be heard according to this view, even if the value claimed is only 1 peruta. So the Gemara asks, and with regard to the Tana of our Mishnah, what is the reason that he does not teach the case of the convening of judges in his list of cases involving perutot? And the Gemara answers, well, he taught the case of robbery, which includes all monetary claims that one has against another. Once you know that you can bring a claim of robbery for 1 peruta, then that you learn out from that any kind of claim that you could bring before a rabbinic court has that minimum value of a peruta. Now, what's interesting is there are things that you would say are important, even though they don't have a monetary value of 1 peruta, right? Now, reputational harm, you could say, does have monetary value, but we could probably come up with a case, where somebody caused damage to somebody that's real, but it just doesn't have monetary value. So then could that case be brought not under the law of monetary claims, perhaps under a separate law? I'm just spacing. I can't come up with such a case right now, but maybe somebody will help me out. Now, the Gemara asks, but doesn't the Tana teach the case of robbery and teach the case of lost property, meaning that these are brought with a minimum value of a peruta? So apparently he lists monetary cases that are included under the rubric of robbery. So since you're saying that robbery includes our monetary cases, and yet that list of 5 includes other monetary cases, that we wouldn't use the catch-all of robbery, so then why isn't convening judges included in that list? So the Gemara answers, with regard to these 2 cases, it was necessary for the Tana to teach them separately, as there is a novel element in each. The novel element in the case of robbery is not only that a robbery of 1 peruta is considered robbery, But also in the case of one who robs an item from another worth at least one peruta, and then took an oath to him that he robbed nothing, then it kicks in this obligation that he has to return it personally, even if the owner that he robbed has traveled all the way to Metzia, some far off land. And the novel element in the case of lost property is that one who finds lost property, the value of with the value of at least one peruta, he is obligated to proclaim what he found, even though the lost article depreciated and it is no longer worth one peruta. And the Gemara asks, and as for Levi, what is the reason he does not teach that one is obligated to proclaim that he found lost property only if it was worth at least one peruta? And the Gemara answers, he taught the case of robbery, which includes all monetary claims one has against another, right? So two different sages made two different lists of 5 things based on a peruta. Since their lists are different, we're trying to understand what was their thinking in drafting different lists. And the Gemara asks, but doesn't he teach robbery and also teach the convening of judges? So apparently he lists monetary cases that are included under the rubric of robbery. And the Gemara explains, with regard to the convening of judges, it was necessary for the Tana to specify the law to exclude the opinion of Rav Katina. As Rav Katina says, the court attends to monetary claims of even less than the value of one peruta, and anyone wronged by another is entitled to have his case adjudicated in court. And the Gemara asks, and as for Levi, what is the reason he does not teach the peruta of misuse of consecrated property? And the Gemara answers, he is speaking with regard to non-sacred property. He is not speaking with regard to consecrated property. But in the case of the Tan of our Mishna, who is speaking with regard to consecrated property, let him teach the halacha that second tithe may be redeemed only if the produce is worth at least one peruta. And the Gemara answers, the Tana holds in accordance with the one who says, second tithe is redeemed only if it's 1/5, which he adds when redeeming his own produce, is worth at least one peruta. In other words, second tithe is redeemed only if it is worth at least 4 perutas, so that the one, as we already learned how to calculate the 5th, it's from without, 1/5 of what the total money of redemption would be. So if produce is worth 4 perutas and you have to add 1/5, you pay 5 perutas because it's 1/5 of the total, the value of the principal plus the 1/5 that you added. And so therefore, you only redeem this when you're adding 1/5 if the principal has a minimum value of 4 perutas. And let him teach that second tithe is redeemed only if it's 1/5, which one adds when redeeming its own produce is worth at least 1 peruta. And the Gemara responds, the Tana is speaking with regard to the principal, and the Tana is not speaking with regard to the 5th. Now, with regard to the matter itself, raised in the previous discussion, the Gemara elaborates. Rav Katina says, the court attends to monetary claims of even less than the value of 1 peruta. Rava raises an objection from a baraisa. It is written, and he shall make restitution for that which he has done amiss in the sacred matter. That's Leviticus 5:16. Now we're on page 55b, and this is a shorter side than the A side. And this serves to include misuse of consecrated property less than the value of 1 peruta in the laws of restitution to the temple treasury. And the Gemara infers to the temple treasury, yes, one must return that which he took. But to an ordinary person, no, one need not pay restitution for a theft of less than 1 peruta. Rather, if Rav Katina's ruling was stated, this is how it was stated. Rav Katina says, if the court attends to a monetary claim of the value of 1 peruta, the judges conclude adjudicating and issue a ruling, even if the item in question depreciated to less than the value of 1 peruta during the course of the trial. For the beginning of the legal proceedings, we require that the claim be worth at least 1 peruta, whereas at the verdict stage, we do not require that the claim is still worth 1 peruta in case the value of the item has depreciated. And that concludes our discussion of Mishnah number 5 here in chapter 4. Now, Mishnah number 6. In this Mishnah, as in the previous one, the Tana enumerates several laws that share a common element. There are 5 halachic situations where 1/5 is added to the value of the principal, and these are they. A non-priest who eats either terumah Or, right, terumah is only for priests. It's the first 2% of the produce, and it's given to a priest, and only priests can eat it, and they can only eat it when they are tahor, in a state of ritual purity, and the terumah itself is in a state of ritual purity. So, this is where we add a fifth. So if a non-priest eats either terumah or terumah of the tithe, so terumah of the tithe means that a Levite, when he receives the tithe, right, the next 10% of all produce after the 2% for the priest, the next 10% goes to a Levite. Levites didn't receive portions of land at the time that the land of Israel was distributed, when Joshua led the Jews in after the Exodus from Egypt, which we just celebrated, which we are celebrating in the festival of Passover. So the Levites would receive a tithe. When they receive a tithe, they have to set aside 10% of what they receive and give that to the priests. And that's called terumah of the tithe. And we actually learn out from that in modern times, even one who lives on charity from the community must give charity from what he receives. So, right, again, where does a person need to add a fifth? So a non-priest who eats either terumah of the tithe, or terumah of the tithe of demai, that's doubtfully tithed produce, or challah. Right, so challah, we call it challah because it was a portion of the dough that is set aside and given to a priest when we bake bread. And still today, if a woman is making enough challah at one time, there's a minimum amount for that. I think it's 5 pounds of flour, something like that. Then she sets aside challah, and we don't give it to priests in modern times, but we don't eat it either. So that's usually burnt and set aside, and then it's often used as part of the chametz process that gets burned at Pesach, right? Which we did on the morning before Pesach began. Or challah, or first fruits. So in each of these cases, right? So all of these items, terumah of the tithe of demai, challah, or first fruits, those are all foods that only priests can eat. And if a non-priest eats it unwittingly, he has to replace what he ate and add a fifth. And one who redeems his own fruit of a fourth-year sapling or second tithe produce adds a fifth. So we've talked about redeeming your own meiser sheni, your own second tithe, that you add a fifth. Fruit from a fourth-year sapling was like this. So for the first 3 years that a fruit tree is bearing fruit, we can't eat it. That's called orla. We don't eat fruit of trees that are 3 years old or younger. In the fourth year, it becomes permitted to eat it, but you have to bring that fruit. It's treated like meiser sheni. You have to deconsecrate it and then take the money up to Jerusalem and spend it there during the festival. This is when the temple was standing. Now it would be deconsecrated just for a small amount of money. The interesting wrinkle of fruit from a fourth-year tree is that if, when the temple was standing, this fourth-year tree is producing fruit within a certain distance of Jerusalem, which was like about a day's travel, then he was not allowed to redeem it like meiser sheni onto money and bring the money to Jerusalem. Rather, he was obligated to bring the fruit to Jerusalem for the festival, and this would ensure that the streets of Jerusalem were awash in beautiful, ripe fruit, just harvested fruit, which would decorate the city for the festivals. And this was by rabbinic decree. Now, one who redeems his own consecrated property adds a fifth, as we've learned. One who derives benefit worth 1 peruta from consecrated property adds a fifth when he replaces it. And one who robs the value of 1 peruta from another and takes a false oath in response to the person's claim adds a fifth when paying restitution. That's Mishnah number 6. Now the Gemara. Rava says, Rabbi Lazar found the law in the Mishnah with regard to terumah of the tithe of demai, right? So terumah of the tithe, that's the Levite paying terumah to a priest. Now of demai, of doubtfully tithed produce. So he received produce, let's say he bought it, I guess from a Levite. Demai just means you bought it from somebody that you're not sure if they followed the laws and tithed it. So it's doubtfully tithed produce. and normally as a stringency, we tithe it even though it might have already been tithed, because we don't want to take the risk of eating from untithed produce. So now we're talking about terumah of the tithe of demai. And Rava says that Rabbi Elazar found this law difficult. And he asked, and since the obligation to tithe demai is by rabbinic law, did the sages reinforce their pronouncements and render them parallel to Torah law by requiring the addition of 1/5 when paying restitution? Right? Adding a fifth when redeeming second tithe, for example, that's by Torah law. Are we going to say that now when you're redeeming something that's only by rabbinic law, in this case demai, or even terumah of the tithe of demai, that we also add a fifth? Do we really elevate rabbinic decrees to that level? And Rav Nachman said that Shmuel said, in accordance with whose opinion is this Mishna? It is in accordance with the opinion of Rabbi Meir, who says the sages reinforced their pronouncements, yes, and rendered them parallel to Torah law, as it is taught, for example, in a Baraisa, with regard to an agent who brings a gett, a bill of divorce, from a country overseas. If he gave it to the woman, but did not say to her, when he handed it to her, that this gett was written in my presence and it was signed by your husband in my presence, which is required by rabbinic ordinance, then her gett was not a final gett, right? The gett came from her husband and this guy delivered it. But because it came from overseas, the rabbis added additional strictures to make sure that the divorce is a valid divorce. And part of that was that the agent would say, this gett that I'm delivering to you from your husband, it was written in my presence and signed in my presence. If he doesn't say that, then the proper procedure, according to the rabbinic ordinance, was not followed. So is the woman actually divorced or not? According to Rabbi Meir, she's not. So if he didn't say it was written in my presence and signed in my presence, then somebody who comes along and marries the woman next must divorce her. And if there was offspring from that second marriage, the offspring is a mamzer. Very harsh penalty. This is the statement of Rabbi Meir. But the majority, the rabbis, overruled Rabbi Meir. And they said, although this divorce was not finalized because the agent didn't make that declaration, and this is in violation of the ordinance, nonetheless, the offspring from her second marriage is not a mamzer. How then should the agent proceed? He should take the bill of divorce from her and give it to her again, and this time in the presence of two witnesses, and say to her, it was written in my presence and signed in my presence, so that all will know that there's no even room for doubt that the offspring is not a mamzer. So that she has a solution, and that's obviously a much better outcome than Rabbi Meir's very stringent holding. So we follow the majority, not Rabbi Meir. So now we're just saying, well, okay, but according to Rabbi Meir, who seems to be elevating rabbinic ordinances to a level of stringency normally reserved for Torah laws, so the Gemara asks, and according to Rabbi Meir, although the bill of divorce was otherwise valid, merely due to the fact that he did not say to her, it was written in my presence and signed in my presence, must the second husband divorce her and their offspring is a mamzer? And the Gemara says, yes, as Rabbi Meir conforms to his standard line of reasoning, which we learn from, as Rav Hamnuna says in the name of Ula, that Rabbi Meir would say, in the case of anyone who gives a bill of divorce that deviates from the formula coined by the sages with regard to bills of divorce, one who then marries the divorced woman on the basis of that flawed bill of divorce must divorce her. And if they had offspring, the offspring is a mamzer because she wasn't properly divorced. So, concerning terumah of the tithe of demai as well, Rabbi Meir reinforced the pronouncements of the sages and rendered them parallel to Torah law in the sense that he would add the fifth when redeeming. So Rav Sheshes raises an objection to this principle from a Mishna and tractate demai, which teaches one may desacralize silver coins of second tithe of demai upon other silver coins, and copper coins may be desacralized on copper coins, and silver coins may be desacralized on copper coins, and copper coins may be desacralized upon produce. And he may then redeem that produce with money. This is the statement of Rabbi Meir. And the rabbis say that produce that redeemed the copper coins must be taken up and eaten in Jerusalem. It may not be redeemed again. So here it would seem that Rabbi Meir is being more lenient than the sages. So Rav Sheshes continues, and can one desacralize silver coins with copper coins? But didn't we learn in a Mishna, in Meiser Sheni 2:6, in the case of a silver sela of second tithe and a sela of non-sacred property that were intermingled, one brings copper ma equaling the value of a sela and says, wherever there is a sela of second tithe among these two coins, it is redeemed upon these copper ma, which assume the sanctity of the second tithe that I've redeemed, and he selects the better quality sela among the two and redeems the copper coins upon that sela. And the result is that the better quality sela is second tithe, while the other sela and the copper coins are non-sacred. I'm almost done. Questions or comments, please get them in now. The reason one must employ this procedure is due to the fact that the sages said one desacralizes second tithe silver coins upon copper coins under duress. And it is not that he will maintain them in that form. Rather, it is that he again desacralizes them upon silver coins. So in any event, the Tana teaches that one desacralizes second tithe coins in this manner under duress. And from this, it may be inferred that under duress, yes, but if you're not under duress, no, then you can't do that. So this is the law with regard to redemption of second tithe coins by Torah law. By contrast, in the case of demai, where the requirement to doubtfully tithe produce is by rabbinic law, Rabbi Meir permits desacralizing it in this manner ab initio. So apparently Rabbi Meir is more lenient with regard to matters of rabbinic law than he is with regard to matters of Torah law. Obviously, in some cases, he is more lenient. In others, he is more stringent. Reminder that tomorrow, Sunday, we're going to have class at a special time, noon Pacific, and that's because tomorrow night we're entering Chag again, 7th and 8th day of the festival of Passover. So tomorrow's class is at noon Pacific, and then we'll have no class on Monday and Tuesday, and we will resume class on Wednesday. Okay, a comment from Bell. I have seen civil claims in which the plaintiff was found to have been legally harmed, but the award was only $1 by the judge. Exactly what I was talking about earlier, that sometimes you have a claim that doesn't really have monetary value, but is nonetheless important, often having to do with reputation, where the value is difficult to judge. And I was trying to come up with another example that is not connected to reputation, but I couldn't think of one then. That is what I've got for today. With God's help, we'll be together again tomorrow, as I said, special time, noon Pacific. Have a great night, good vach, and good moed. A good week and a good intermediate days of Passover.